Setting up a UK partnership may be very advantageous for international investors wishing to conduct an international trade or business. UK partnerships offer many tax advantages and tremendous organisational flexibility for the partners. In this video, I'm going to look at 3 registered partnership forms in the United Kingdom. Firstly, the UK Limited Liability Partnership, or LLP. Secondly, the Scottish Limited Partnership. And finally, the English Limited Partnership. So we'll look at the tax and organisational advantages of each type of partnership, starting with the Limited Liability Partnership, or LLP. The LLP is registered under the LLP Act 2000 and is a body corporate. That makes it a company. An LLP must have at least 2 members, and these members may be individuals, companies, trustees, partnerships or foundations or any combination of these. The identities of the members must be registered at UK Companies House. Typically, there will be 2 corporate members for international joint venture arrangements and for cross-border trading arrangements conducted by one party. The LLP itself pays no UK corporation tax or UK income tax. Instead, any income or gains or losses flow through the LLP to the members themselves. In other words, the LLP is tax transparent. If the LLP's income has a non-UK source and the members of the LLP are non-UK resident, no UK tax will apply to that income. This tax neutrality explains the popularity of UK LLPs in international transactions and joint venture arrangements. International investors can benefit from a well-regulated and trustworthy UK law framework for their business, supported by legal, tax and accounting professionals based here in the UK. Another reason for the popularity of the LLP is that it offers limited liability for each member. All LLPs must maintain a UK registered office address. LLPs can register for VAT and must file annual statutory accounts at Companies House. The publication of statutory accounts is helpful where an international entity is required to raise finance, for example. Being a legal entity, the LLP can contract with the bank, own its assets, and pledge its assets by way of security, and the lender can monitor the LLP's financial position. Jordans can support the LLP in this regard with the production of management accounts if this is required. The members of the LLP normally take an equal part in the management of the company. But the LLP agreement, which is a private document, can vary this position, and there is very significant flexibility to provide for an almost infinite variety of management and profit-sharing arrangements. Next, let's look at Scottish and English limited partnerships. Like LLPs, Scottish and English limited partnerships are tax transparent under UK law, but they don't have a corporate form. They're registered under the Limited Partnerships Act of 1907, and on registration they're issued a unique registration number by Companies House in the UK. While a Scottish limited partnership must maintain a registered place of business in Scotland, an English limited partnership must do so in either England or Wales. If the partners of either a Scottish or English limited partnership are all non-UK resident, and if their partnership income is generated outside the UK, there are no UK tax liabilities on such income. So they're taxed in the same way as the LLP, which we saw earlier. This makes limited partnerships very popular as funds vehicles and as international business vehicles for non-UK residents. Under the Limited Partnerships Act, there are 2 types of partner which must be registered. The general partner manages the partnership business and has unlimited liability for the debts and obligations of the partnership if these can't be settled out of the limited partnership's assets. Then there are limited partners who have limited liability, provided that they don't participate in the management of the partnership. General and limited partners may be individuals, companies, trustees, partnerships or foundations, or any combination of these. Where the limited partnership operates internationally, it's not untypical to see a two-member limited partnership with both the general and limited partner being offshore companies. The use of corporate general partners certainly mitigates the unlimited liability of the general partner. The identities of the general and limited partners must be published at UK Companies House. The main distinction between these two types of limited partnership is that Scottish limited partnerships have a separate legal personality, and this may create so-called hybrid tax status. This can offer tax advantages if the partners come from a country that treats the Scottish limited partnership as a company, in other words, as opaque for tax purposes because of its separate legal personality. On the other hand, the English limited partnership, because it does not have a legal personality, cannot normally achieve this hybrid tax status. Incidentally, Scottish limited partnerships and English limited partnerships will avoid the UK's new transparency proposals that require persons with significant control of the company to be publicised. We saw earlier that LLPs must file annual statutory accounts. In the case of limited partnerships, whether Scottish or English, if all the general partners are bodies corporate, then the limited partnership must prepare annual statutory accounts too. These will have to be filed at UK Companies House if the limited partnership has any UK companies acting as general partners. However, if any of the general partners of a Scottish or English limited partnership are individuals, or UK or offshore LLPs, or offshore foundations, then the requirement to produce statutory accounts and to file them is avoided. All the UK partnership entities that I've described provide international investors with a stable, limited liability vehicle subject to appropriate planning. Furthermore, each of these entities is registered at UK Companies House with its own unique registration number. Moreover, with appropriate planning, the income and gains of these UK partnerships will not experience UK taxation, provided that the partners themselves are non-UK resident and the trade or business that they conduct through the partnerships do not have a UK source. The main decision to make is the choice between a UK limited liability partnership or a limited partnership. If the partners of the partnership wish to keep the financial results of the business confidential, then it may be preferable to consider a limited partnership, either an English or a Scottish limited partnership. On the other hand, if the investors wish to publish their accounts, their financial results, perhaps because suppliers will insist on such transparency or to meet the needs of a lending institution, then a limited liability partnership or LLP may be the appropriate vehicle. For further specialist advice in relation to any of the points raised in this programme, please do get in touch with us. Jordans are specialists in registering, administering and structuring partnerships, companies and trusts both in the UK and overseas.